Hello everyone, welcome to Legal Darshan. In this video, we are going to look at the case of Ssangyong Engineering and Construction Co.Ltd versus National Highway Authority of India. Now, this case is relating to Section 34 of the Arbitration and Conciliation Act, and Section 34 of the Arbitration and Conciliation Act provides for setting aside of arbitral awards by the court. Okay, so courts do have jurisdiction to set aside an arbitral award if they abide by the provisions given in clause 2 and clause 3 of the section 34. Okay, now clause 2 of section 34 of Arbitration and Conciliation Act provides, the A subclause provides that if the party making the application establishes on the basis of record of the arbitral tribunal that party was under some incapacity, arbitration agreement was not valid, or the party making the application wasn't given any proper notice of appointment or the arbitral proceedings, or in any which way the party was unable to present the case, in that case also the court may set aside the arbitral award. However, it is awarded, it is settled that it is established on the record of the arbitral tribunal. Okay, so this particular provision is in light in this case. And if you look at 34 to A3, if we look at this section, it is basically holding up the principle of audio alterum partem, which provides that no party should be left unheard. Now, coming on to 34 clause 2, subclause B, that is also saying the court may, if the court finds that an arbitral award may be set aside if the court finds that number one, subject matter is not disputed, is not subject matter in the dispute is not capable of being settled by arbitration. And point number 2, the Roman number 2, that the award is in public conflict with the public policy of India. Explanation 1 provides that award is in conflict with public policy of India only if it is vitiated by fraud or corruption, is in contravention with fundamental policy of Indian law, or it is in conflict with the most basic notions of the morality or justice. Okay, then only we will say that it is in breach of the public policy of India. And the court and the explanation 2 is also clarifying here that whether there is a contravention of public fundamental policy of Indian law, it will not affect the merits of the case. There is another section which is in light in this case, is section 34 clause 2A. Now, this is saying that an arbitral award arising out of arbitration other than the international commercial arbitration may also be set aside by the court if the court finds that the award is vitiated by patent illegality appearing on the face of record. So by this amendment comes in 2015, and patent illegality. Okay, patent illegality becomes the ground on which an arbitral award may also be set aside. Now, this judgment being given by Justice Nariman and Justice Saran is also expounding upon what public policy is and what is patent illegality. How do we configure whether an award is vitiated by, violation of fundamental policy of Indian law and also violative of public policy of India, or there is a patent illegality in the award that is given. Coming on to the brief facts of the case. Now, what happens is that Ssangyong and NHAI, the National Highway Authority of India, it comes in an agreement, comes in a contract with respect to construction of a highway in Madhya Pradesh. Now, a dispute arises regarding cost adjustment for the raw material under the contract. Okay, now there is a particular clause in the agreement that provides that there can be price adjustment on the basis of decided parameters. However, after the contract is signed, the National Highway Authority of India issues a circular. Now, this circular is being issued unilaterally, which modifies the adjustment formula for cost. Okay, now earlier the formula was something else, and by this circular there is another formula, and which is also denying escalation cost for the raw materials herein. Now, basically, this particular dispute arises, and the case goes before the arbitration tribunal, and the arbitral tribunal favors the respondent, holding that the unilateral circular, since it was governmental authority issuing the circular, it is upheld. There was three arbitrators in the arbitration tribunal, and by 2:1 majority, an award is passed allowing the application of the new formula to the contract to compute the cost, compute the price payable to the appellant herein, that is Ssangyong Engineering and Construction Co.Ltd. Okay, now the court, what is the issue before the court herein? The first thing that is being challenged is it is on the basis of 34(2)(a)(3), which we discussed is a right of audio alterum partem. Okay, and this can only be invoked when the party who is filing an application under Section 34 of the Arbitration and Conciliation Act brings on the record of the arbitral tribunal that his right of being heard fairly, his right of audio alterum partem is being violated. Another issue that arose before the case, before the judges in this case, was the violation of Section 34, Clause 2, Subclause B2. Okay, now when we look at the issues, okay, so the appellant herein is inter alia pleading that Section 34(2)(b) was attracted to the award, as the award that is being passed herein is in conflict with the public policy of India. Okay, so now this case, basically he is alleging that the award is being passed in violation of public policy of India, and the court herein is examining what public policy should be in this particular case. Okay, now yes, basically the arbitral award was set aside in this case, but what makes the court set aside the arbitral award, we are going to have a look at it now. Okay, now the first issue is that whether a unilateral circular, okay, now there is an agreement between the two parties, one is Ssangyong and one is NHAI. Can NHAI issue a unilateral circular and override the contractual terms on which the contract has been made, and whether the arbitral award is liable to be set aside as against public policy of India, or whether it is patently illegal when a unilateral circular is issued and that unilateral circular is upheld by the arbitral tribunal itself. Okay, now the court herein is holding that number one, the NHAI circular could not override the contractually agreed escalation formula, because there was a contractually agreed escalation formula for cost adjustment, and unilateral circular of NHAI cannot invalidate that contractual agreement on the formula, and the arbitrator's reliance on such a circular amounted to rewriting of the contract, which is impermissible, because what is happening now, there is a unilateral rewriting of the contract which the arbitral tribunal is also enforcing. That the appellant herein is also taking the plea that pursuant to Section 34(2)(a)(3), Section 34, subsection 2, Clause A, Subclause 3, the Ssangyong, that party was also unable to present its case. Okay, basically when the tribunal in this case has taken material behind the party's back, and the party, okay, this party Ssangyong, it did not have any opportunity to defend its case on that particular material which was taken behind the back. And now the court herein is saying that provisions under Section 34(2)(a)(3) stands strong, stands attracted, because there is a denial of giving fair hearing throughout arbitration proceedings to the appellant herein. Okay, now on the question of public policy being challenged in India, the court, public policy of India being challenged, the court is saying that there has been a 2015 amendment, and court is emphasizing that after 2015 amendment, mere errors of law or fact do not constitute violation of public policy. Because when we looked at the section, okay, when we were looking at section explanation, this is an amended provision. Okay, we see the brackets here. This is an amended provision, and it is saying, it is clarified that an award is in public policy of India only if it is vitiated by fraud or corruption, it contravenes the fundamental policy of Indian law, and it is in conflict with the most basic notions of morality and justice. Okay, now the court reaffirms this particular amendment, and the court is saying that, yeah, the court is saying that the award here is basically violating the contractual sanctity. Now, in Indian law, contractual sanctity is something we maintain. You know, if a contract is saying that XYZ is the terms we are agreeing on, you cannot override the contractual agreement by violating the general principles of contract as well. So, general principles of contract do form a part of fundamental law of Indian policy, fundamental law and fundamental policy in Indian law as well, right? Now you cannot write over them just because of the fact that you are a government affiliated authority and you have the power to issue circulars, right? Now 2015 court is also looking at the 2015 amendment by which we had section 34 clause 2a. Okay, so section 34 clause 2a also provides that first, that it will only apply to domestic arbitrations when both parties are Indian, or when the arbitration is domestic. Okay, and it allows the court to set aside an arbitral award only if there arises patent illegality on the face of the award. So Supreme Court is also using patent illegality in this case and is clarifying that when the arbitral tribunal rewrote the contract by affirming with the unilateral circular issued by NHAI, it is also patently illegal. And the court clarified herein that what patent illegality means. It means that you are ignoring vital evidence. It means that your decisions are such that no reasonable person could arrive at. Your decisions are perverse, suffering from perversity, and there is contravention of contractual agreement, that the terms that have been agreed between both the parties. Now, before, when we go to pre 2015 amendment era, public policy of India was a broader ground under Section 34. So courts often interfered with the arbitral award, and they were, setting aside those arbitral award because what exactly is public policy? There was no clue on that. Okay, so there were cases like ONGC versus Saw Pipes, which had a broader public policy test, and therefore there was a wider interference of the courts in the arbitration awards. Now, by way of this judgment, also the court is reaffirming that the scope of setting aside is particularly narrow, and only when Section 34 grounds are satisfied, the court may set aside the arbitral award, not otherwise. Therefore, it is also reaffirming a narrower test post 2015, saying that 2015 amendment intends to reduce judicial intervention in the arbitral awards as well. Now, court herein are also saying that 2015 amendment, the 34(2)(a) coming by 2015 amendment, patent illegality being the cause of striking off the arbitral award, will apply prospectively after the date of implementation of 2015th amendment as well. Since this case is a 2019 case being decided in 2019, court intervened also on the grounds of patent illegality. Okay, court said that award clearly violated the contract, and thus it did not just violate it with the fundamental policy of the Indian law, which is also the general principles of contract, but also it triggered section 34 clause 2a, which is patent illegality, and not mere and therefore the award is liable to be set aside. Now, if we look at pre 2015 position, it had a broader interpretation of public policy. Of course, before 2015, we did not have a patent illegality as a ground. Therefore, the judicial interventions, because of broader application, were higher, and courts were even reappraising evidence as well. But when 2015 amendment comes in, Ssangyong is also making a comment on 2015 amendment, holding that the intent of the legislature is narrow application of section 34. It is narrowing down the application of 34 and limiting it only to the core violations, that is fraud, corruption, morality, and also fundamental policy. Now the court is also saying that when you are overriding the contractual terms, you are also violating the most basic notions of morality and justice as well, and also therefore it becomes a breach of fundamental principle of justice, which would shake the conscience of the court as well. That is also an argument that the court is making. Ssangyong is also applying patent illegality test and is making a comment that judicial review shall only be restricted to serious defects, serious procedural defects, and it should not, go into the merits of the case. It should not adjudicate the merits of the case, but rather should stick to only the grounds that are mentioned in the explanation to 34.2, as well as on the basis of 34.2a, which is providing the ground of patent illegality. Okay, and also the court cannot reappreciate the evidences unless there is a strong indication of the order being very much perverse, right? So this is one case on Arbitration and Conciliation Act in India, basically dealing with 2015 amendment, majorly highlighting what public policy in India holds out and what are, what is patent illegality. The court is also adjudicating it. Okay, so one thing is very much clear, that the award in this case, the award is set aside only on majorly on the basis of patent illegality, because court held that arbitral tribunal had rewritten the contract clearly, and which is not the purpose of an arbitral tribunal. Okay, so the award became patently illegal. And also the court here, and when it talks of public policy, it is narrowing down the scope of public policy in this judgment as well. Okay, and the court specifically mentioned that we are not reverting back to the ONGC versus Sawpipe approach, which was a broader approach, and the court could invoke public policy on any ground. All right, so now court herein, we can come at the conclusion that patent illegality is something which has been reckoned in this case, which has been invoked in this case for striking the award, for setting aside the arbitral award. And the court reminded in this case that judicial review is not an appeal, but rather just a merit based rather just a procedure based check and not the merit based check. Okay, judges cannot reevaluate evidence and substitute their own interpretation. Intervention is allowed in rarest of the rare cases where there is a gross violation of justice which shakes the conscience of the court. So this is it for the video on Ssangyong versus NHAI. I hope the discussion is useful. Thank you for watching. Please stay tuned with Legal Darshan. Have a great day.